I asked myself a question. I knew the answer, but I'm recalling from the 1979 revision of the Rules of Professional Conduct about lawyers reporting misconduct. But it changed. I threw it out there a lot. So let's go there. No, lawyers are generally not required to report themselves for violating the rules of professional conduct. The mandatory reporting obligations established in the ABA Model Rule 8.3, which is basically every state, and corresponding state ethic codes, see, that's what it says, only requires a lawyer to report professional misconduct of another lawyer or judge. See, it says another lawyer or judge. But they don't do that. If you go through the criminal conviction, lawyer are typically required to self-report certain criminal convictions, such as felonies to which the state's disciplinary authority. Okay, so the primary exceptions when a lawyer must self-report include criminal convictions. Lawyers are typically required to self-report certain criminal convictions, such as felonies, to their state's disciplinary authority. They did that when people were locked up, started studying the law, became lawyers, wanted to be lawyers. So in order to be lawyers, they'd have to report that. And they tried to make it to where they couldn't, but if they had the aptitude, they could pass the bar. They said no, because they're ex-convicts, they're ex-felon, class X. What? They did the time, serve the time, did the crime, whatever. They got out, they got an education on their own, and they didn't want them to be lawyers. They said no. But that eventually changed. Out-of-state discipline. If a lawyer is disciplined or disbarred in another jurisdiction, they must self-report that action. Okay, people, remember, violating the rules of professional conduct, knowingly and willingly violating the rules of professional conduct, is a federal crime. Okay, so you're going to have to hit them with the federal crime. Okay, because, look here. When a lawyer knowingly defies the rules of professional conduct, and they all do, they commit professional misconduct, subjecting them to formal investigation and disciplinary actions. Consequences range from private reprimands to permanent disbarment, depending on the severity of the law, violation of the attorney's disciplinary history, who investigates and prosecutes. Violations are investigated at state-level disciplinary bodies, typically operating under the state Supreme Court. For lawyers practicing in Hickory Hills, Illinois, the governing body is Illinois Attorney Registration and Disciplinary Commission. Useless, I did that. The RDC investigates complaints, holds hearings, and recommends sanctions to the Illinois Supreme Court, which holds ultimate authority to discipline lawyers. Common sanctions imposed depending on the gravity of defiance, e.g. trust, account theft, lying to a judge, client's abandonment. Like I said, one of my other videos, you question about the rules of professional conduct, they'll just quit on you, and that's client abandonment. They can't do that. It's in the rules of professional conduct. The court may issue the following penalties: reprimand, abomination, a formal, often public warning for minor or technical rule violations. And as I said in my other video, if you read the rules of professional conduct, you'll find it's impossible to violate just one rule in the rules of professional conduct. You violate one, you wind up violating multiple times, and that leaves the preamble and the scope irrelevant. Probation: the lawyer is permitted to keep practicing, must comply with specific conditions, mental health treatment, office practice audits, or mentorship. Suspension: the attorney loses the right to practice law for a set period. 6 months to 7 years. No, well, we'll get to that. Disbarment. The complete permanent revocation of attorney's license to practice law, and that's usually just in the state. That should be throughout the states. They should be blacklisted throughout the United States. Same thing with any public servant, political, anybody behind a badge. In addition to losing their license, defying the rules can trigger severe professional and legal fallout. Contempt of court, knowingly misleading a judge or withholding controlling legal authorities can lead to fines or jail time. Malpractice liability. Ethical violations can be used as evidence in civil malpractice lawsuits brought by aggrieved clients. Criminal charges if the rule violation constitute a crime, e.g. client fund embezzlement, evidence tampering, or fraud. The lawyers will be prosecuted in criminal court. Okay, so like I said, it's impossible to violate one rule without violating a whole bunch of other rules. So that's why I put what happens if a lawyer knowingly and willingly violates the rules of professional conduct. When a lawyer knowingly defies the rules of professional conduct, I was supposed to put knowingly and willingly because that's how they use it in court of law, legal context, knowingly and willingly. Okay, but that's a deprivation of rights. Okay, let's put that. What? Well, violating the oath. If they don't abide by the rules of professional conduct, that's violating the oath. Okay, because if you look up their their oath of office, lawyer's oath, it'll say they take an oath to the Constitution, and the Sixth Amendment of the United States Constitution guarantees you effective assistance of counsel. Defying effective assistance of counsel is deprivation of rights. Okay. So anybody knowingly violating the oath is deprivation of rights. Okay. Let's put that knowingly. And knowingly and willingly violating the rules of professional conduct, not inherently a deprivation of rights. Professional ethics and federal constitutional rights operate in separate legal dominion. Professional conduct, these are ethical and regulatory standards. While any violation may be intentional, the consequences are generally administrative. Deprivation right. This is meant threshold. It typically requires acting under the color of law, which they were. You read the rules of professional conduct, they ain't doing that, and that's effective assistance of counsel. Okay. So let's go to effective assistance. Okay, there it is. Yes, ineffective assistance of counsel is a deprivation of constitutional right to legal representation. This guarantees under the Sixth Amendment of the U.S. Constitution, applicable to state versus the 14th Amendment, to prove a specific deprivation of rights in court of law, a defendant must satisfy the Strickland versus Washington two-part. Deficient performance. The attorney's performance fell below an objective standard of reasonableness based on prevailing professional norms. And that's easy to prove when you use the rules of professional conduct. They didn't do that. Those are their constitutional duties, not just your legal right to effective assistance to counsel, but their constitutional duties. That's what they have to do in order to maintain a license to practice law. Any violation, they're supposed to be zero tolerance. Zero tolerance. And they tolerate anything because everybody's doing it. Prejudice, there's a reasonable possibility that but for the attorney's unprofessional errors. They are not errors, they are knowingly and willingly. One does not err when violating the rules of professional conduct or the code of judicial conduct. That's knowingly and willingly. What can they say? They forgot or they didn't remember. Remember the simple term, ignorance of the law is no excuse to hold it against you, so hold it against them. You didn't go to law school. They did. What was the idea of their education and then not doing this? If this constitutional deprivation of rights is proven through a motion or appeal, the court may grant relief such as overturning a conviction, ordering a new trial, or reducing a sentence. To provide you with the most relevant guidance, you are currently evaluating a situation involving a specific legal case or trial scenario, missed deadlines, or failure to call witnesses. I've had plenty of cases where it was a refusal to call witnesses. The judge, the state's attorney, and the defending attorney refused to use witnesses. It limited it to hearsay. The defendant against the plaintiff. That's it. He said, she said, hearsay. The preponderance of evidence was null and void. There was no evidence. And in the end, the judge saying, well, it's left to believe if it's him or her, I'm taking her side, or whatever reason. For whatever reason. But still, like I said, missed deadlines. I talked to a gentleman about a quick and speedy trial. He said he asked for it. But did they live up to the standards? No, they didn't. He told me he was in court for like 13 months and a bond so high he couldn't afford it. That falls under cruel and unusual punishment, okay? The unaffordable bond. And 13 months before they got that, they denied him a quick and speedy trial. He asked for it, but they didn't give it to him. There's limitations, I think, in his state. It was he was incarcerated. He was in detention, so they had 90 days to get him a quick and speedy trial. If he wasn't on trial within those 90 days, the case was to be dismissed. I told him he should have just, based on that, the failure to grant him a quick and speedy trial, he can have the case dismissed with prejudice, just on those grounds alone. But he already served the time, I said, yeah, but still file anyways. You were convicted, and it was all rules, you were denied discovery. Disclosure requires you having access to all this evidence. In court it's called discovery, but it's called the disclosure law. And they didn't disclose to him their legal obligations, their constitutional duties, prescribed in the rules of professional conduct, guaranteed through the Sixth Amendment of the U.S. Constitution. So you're denied effective assistance of counsel automatically, and then how could you get a fair trial? You didn't, because you were denied effective assistance of counsel. One cannot claim you received a fair trial without effective assistance of counsel. So how did due process move along? It didn't. See, so there's a lot of things the internet won't tell you if you don't read. You know, a lot of these laws are interconnecting, but right now, it's still at its infancy. So you'll have to ask yourself a lot of questions. So yes, ineffective assistance of counsel is a deprivation of constitutional right to legal representation. Okay, so and that's proper legal representation. If your lawyer didn't abide by the rules of professional conduct, that's ineffective assistance of counsel, okay? Lawyers can't say, I don't have to do that. And what the hell are you paying them for? What are they getting paid for? What are you, a politician? And even politicians, if you look it up, ethics in politics, that's not happening. File complaints and have them suckers removed from office. Ineffective assistance of counsel. You know, when they hold discovery from you, which they will, you know, even not just the state has to guarantee you a quick and speedy trial, your own lawyer. It's the obligation of everybody in that courtroom to see to it that they stick with the guidelines of a quick and speedy trial. You didn't get it, so nobody said nothing. Nobody, you know, I seen a trial where these two guys got away with shooting at a FedEx driver because they didn't want him in their neighborhood. He happened to be black, they were white. It was a racist thing. It was even proven it, you know. But they exceeded the limits of the quick and speedy trial. So the defending attorney filed for it, the judge granted it, and the case was dismissed with prejudice because the state's attorney didn't file within an appropriate time limit or conduct a trial within an appropriate time limit. So the judge granted, threw the case out. But I personally think that was intentional. So ineffective assistance of counsel, and you can prove your counselor didn't abide by the rules of professional conduct, and reporting misconduct is mandatory in both the rules of professional conduct and the code of judicial conduct. And nobody reported that misconduct, which equates to misconduct, giving you a conspiracy against rights under the color of law. Okay, so everybody gets charged for deprivation of rights, okay, because you had ineffective, so when you charge them, it's going to be ineffective assistance of counsel, prosecutorial misconduct, and judicial misconduct, okay? And you just need the law, the rules, and the codes. Nobody did that. And now they don't have to report themselves, but if I remember in the 79 revision, it said if any lawyer has any knowledge, but now they don't have to report themselves, but they have to report anybody else. Any and everybody else they have knowledge of. It doesn't say they have to be involved in the case, just knowledge of. Same goes with judges too. Any knowledge of any misconduct by any lawyer or judge, it's mandatory to report that misconduct. And nobody's doing it. We see it all the time on TV. I seen people trying to get their kids back and lawyers sitting in there and listening to one lawyer saying, well, you know, if I was in that case, I would do this, I would do this, shouldn't be happening, that shouldn't happen, they're lucky, I'm not. Well, report them for misconduct, you crooked-ass lawyer. That's misconduct. That's a whole lot of misconduct going on in those courtrooms. Why aren't you reporting that misconduct? Just having general knowledge, people. General knowledge. So you think it's just your lawyer or just your county or state? No, it's everybody. Let's not be superficial. It's happening to we the people across the United States of America and its colonies. All the colonies, they get it worse than we do. Puerto Rico, they get it worse than we do. Guam, they get it worse than we do. But if you think the oath means anything to any public servant, you wouldn't be listening to me right now. Because this is required behind the oath. Okay, so not living up to the rules, the codes, that's violating the oath in its essence, in its entirety. See, this is what's behind the oath for lawyers and judges. What they're supposed to do. So violating the oath is deprivation of rights. So ineffective assistance of counsel is deprivation of rights. Ineffective assistance of counsel is nothing simpler than just saying, hey, I'm not going to do my job. This is my job description, legally, morally, ethically. I can held legally responsible for this, as well as criminally for deprivation of rights. Because that denied you effective assistance of counsel. And they took the oath to do that, and that's violating the oath. And then everybody in that courtroom working together to deprive you of effective assistance of counsel, that's a conspiracy against rights under the color of law. Okay, so all you really need is the law. People I've talked to over the phone, I quit doing that because they want to give me the whole case, the whole rundown, before I even get to talk about the law. So they avoid the simplicity. And some people took days, telling me, how you going to understand if I don't tell you? Well, how you going to understand why all that happened if you don't let me tell you what was supposed to happen in the very beginning? It's in the rules of professional conduct when you spoke to your lawyer. Him not doing that is ineffective assistance of counsel, knowingly and willingly defying the rules of professional conduct is ineffective assistance of counsel. Effective assistance of counsel guaranteed in the Sixth Amendment of the United States Constitution guarantees that they do this. In order to be a lawyer, to stay a lawyer, they have to do this. Not doing that, that's deprivation of rights. You have a right to effective assistance of counsel. That's violating the oath. They took the oath to do that. I think it's pretty damn simple. But they won't. So people, I couldn't even get my point across because they didn't want to listen. And it's not that I don't want to hear their stories. That's what brought me to them. I look on the internet. I go on all these social media sites. Actually, I call them anti-social media because there's more anti-social than social. But that's where I go. That's where I look on the internet and I find people and I try to answer their questions. And I try to draw them to legal reform. It's, hey, look at all these videos, all these websites I show you. But they want to talk about it personally. I said, well, there's a lot of answers in there. You just haven't looked. You haven't watched my videos. I just take you through the internet, through all kinds of laws, and explaining to you what should happen, like I just did. So yes, ineffective assistance of counsel is deprivation of your constitutional right. So that's deprivation of rights under the color of law. You can charge your lawyer with, okay? By not abiding by living up to the rule of professional conduct in its entirety. Zero tolerance. Remember, people, that's their job descriptions, and you're their employer. Remember who you are, we the people. Remember? Everybody in the legal circle took an oath to you to serve and protect you. everybody, whether you're working for you directly or indirectly. Remember who you are. We the people. I love the sound of that. We the people. You know, it says America like we the people. You know, that's who I pledge allegiance to. We the people. That's where my loyalty always has been and always will be. It belongs to you. And that's why I keep refusing to charge for this stuff. Stupid, crazy internet keeps telling me monetize and put ads and commercials, and that's not why I do this. I'm not in it for publicity. That's why you're not going to see my face. I'm an old man who wants to see an old man's face. I'm just trying to open your eyes, that's all. That's the whole point here. Opening your eyes so I can open your mind. And I'll always remind you just who the hell you are. We the people, who I pledge allegiance to, who all your public servants took an oath to serve and protect. Remind them, violating the oath is deprivation of rights under the color of law. Look it up, it's on the net. Look up penalties for deprivation of rights under the color of law. And considering the fact that all our public servants are doing it and nobody's being held criminally liable, you know, being charged, you know, look up penalties for violating the rule of law, the letter of the law, you know, anything they mention, penalties for violating that law. And they will do it, but none of them charge each other because they're public servants and they got this imaginary qualified immunity, and qualified immunity is repugnant to the rule of law. Okay, is that hard to understand? Supreme Court clearly stated any law repugnant to the United States Constitution cannot exist, carries no weight, is null and void. Qualified immunity is repugnant to the rule of law. That's what I came to my conclusion when I read the Magna Carta. You know, I went from the Constitution, got the backstory, the Declaration of Independence, got the backstory on that, which led me to the Magna Carta. I don't know what to call this video, so I'm going to end it here. So some people may tell you one thing or another, but when you put this stuff together, you'll come up with what I came up with. And don't forget, you can file an IAC petition to overturn a case. Even if you negotiated your way out, took a plea deal, that plea deal was due to disinformation, a lack of disclosure, you know, ineffective assistance of counsel, prosecutorial misconduct, judicial misconduct. You could use a lot of laws that I've been trying to teach you against them. You know, each video is mostly talking about one law, and now I'm telling you, hey, try throwing a few of them together, but you got to go through them and pick and choose. That's up to you. But I just threw a couple together for you to kind of get you on your way. If I had my way, I would teach a class, make it mandatory. I'd make it mandatory. I read the Constitution when I was in 5th grade, and I understood that wasn't happening. You know, and I had to find out what this due process was, this effective assistance of counsel, because I knew this fair trial wasn't happening. And I was just a kid, but I watched a lot of the news, and so there's a lot of things I had to find out. You know, it took me almost 10 years to find out what effective assistance of counsel was. You know, how to get a fair trial, what due process was. You know. No, 8 years, not 10 years, 8 years. By 10 years, I was the lunatic I am today that preaches about the law. All right? You have a good day. You have a good night. You have a wonderful day. May your Creator always be with you and rain many blessings. I wish you a long life and good health. Good night. Nothing but peace and love, people.